Well, good afternoon, or perhaps I should say early good evening to you all. Thank you very much for joining us. My name is Max Del Mar. I'm a member of the law school here at Queen Mary, University of London, and most pertinently for this evening, a colleague of Sionaidh Douglas-Scott, who is our anniversary professor of law here at Queen Mary, and the author, most importantly, of this book, which we're discussing and celebrating this evening, Brexit, Union and Disunion, the Evolution of British Constitutional Unsettlement. I know we're joined by a number of colleagues and students as well from Queen Mary, and I know I speak on behalf of everyone, Sionaidh, when I congratulate you on behalf of all of us to say how proud and delighted we are to be here discussing your book. So warm congratulations from all of us here at Queen Mary. I've pasted in the program for this afternoon. I hope you can all see that, as well as a link to the book. As you'll see, we have quite a full program, so I'm going to keep my introductory remarks to really a bare minimum. Just there's three things I'd like to do. The first is to thank Edinburgh Law School and Neil Walker for co-hosting this event with us at Queen Mary. This is part of a series of online conversations about recent books in legal and political theory. So thank you very much. And thank you to Neil as well for being willing to be one of the commentators tonight. The second is just a few administrative points. One is that we're recording, as you might have seen earlier. We're recording the presentations tonight, not the general discussion at the end. For the general discussion, what I would suggest is if you have a question, and you can do that as we're going along, if you could type your question into the chat and leave your name as well. At the end, depending on how we're doing with time, I'll either invite you to ask your question or read your question out. And if we don't get a chance to get to it, then at least Sionaidh will have a record of your question. And the third and final thing that I need to do is just to give you a brief introduction to our distinguished panel, and I hope that they'll forgive me for giving just very, very brief introductions. Firstly, I mentioned that our author, and who we'll be hearing from in a moment, it will introduce the book for us, Sionaidh Douglas-Scott, joined us here at Queen Mary in 2015. Before that, held chairs at the University of Oxford and King's College London. She's worked across, for many years, across public law, constitutional law, legal and social theory, human rights, EU law. And if you want to get a sense of the range and depth of her work, then one place to look is her previous book, Law After Modernity, where I have not asked you this, Sionaidh, but I think you might agree that there are all sorts of interesting connections between this book and that one. Also, a book dealing with pluralism, complexity of transnational and global governance. Sionaidh, I had the distinct pleasure of running one of the research centers here at Queen Mary with Sionaidh from 2015, 2018. In 2018, she was awarded a major Leverhulme Fellowship to work on this book. And so what was a loss for the center is a gain for everyone else. Very briefly, to our commentators in order. So we're going to, after Sionaidh's introduction, then have a comment from Kenneth Armstrong, who until just recently was the Professor of European Law at the University of Cambridge, and has published extensively on EU law and policy, including Brexit. And Kenneth, alongside Sally Sheldon and I, are also the editors of the Law in Context series at Cambridge University Press, and we're really delighted that the book is published in that series. Aileen Mcharg is a Professor of Public Law and Human Rights at Durham University and one of the general editors of the leading, certainly one of the leading journals in the field, Public Law. And she has written extensively on UK and constitutional and public law and Scottish constitutional history. Alvin Jackson is the Sir Richard Lodge Professor of History at the University of Edinburgh, and like our other speakers, has also published extensively in the fields of, in particular, Irish history and the history of multinational unions. And I've been enjoying recently his 2023 book, United Kingdom's Multinational Union States in Europe and Beyond, 1800 to 1925, which speaks to many of the themes that we're discussing tonight. And Neil Walker, who I mentioned earlier, who is the Regius Professor of Public Law and the Law of Nature and Nations at the University of Edinburgh, and has done foundational work for a long time on many of the concepts that Sionaidh is also examining in her book, Sovereignty, Constitutional Pluralism in the UK, in Europe and beyond. So I hope you agree with me that we have a really exciting and distinguished panel of speakers and commentators. And without any further ado, I'll just invite you now, Sionaidh, to introduce the book to us.
Right, well, thank you very much. Max, can you hear me? Is that all working okay? Great, yeah. Well, thank you very much, Max. And also thank you, Kenneth, Aileen, Alvin and Neil. I really appreciate your taking the time out. I know the start of term is very busy. It's a long book, so thank you so much. I really value the commentary that you're going to make. So I'm going to try and keep this as short as I possibly can, but one of the questions was, why did I write this book? And I wrote this book because Brexit wrought absolutely huge changes to the United Kingdom. And an awful lot has been written about the changes that were wrought to Britain leaving the EU, particularly in the trade area. But I felt that there really wasn't an aspect of UK life that Brexit didn't touch on. And some of the greatest challenges posed by Brexit are those it places on the British Constitution, which is already unsettled, which is a term I borrowed from Neil Walker, but I think it captures very much what was going on and under strain. And so my book investigates this aspect, that there is a whole area of British constitutional unsettlement, what I call inadequacy, aspects of the British Constitution that were seen to be unsatisfactory, that Brexit problematized. But also, additionally, the second major question I had in researching this book was looking back at British constitutional history, because I realized that Brexit is a very, very major act of disunion, of separating the United Kingdom from the EU. But this is not the first act of union or disunion that the UK has undergone. There have been many, many. But in a way, it's rather unexpected that so many of them have been somehow swept under the carpet. And I think that there are many insights to be gained from investigating earlier disputes as to the meaning of British statehood, sovereignty, and territorial boundaries, such as the loss of the former US colonies from Britain in the 18th century, the British Empire and subsequent British Commonwealth in the 19th, 20th century, and also, very importantly, the places of Scotland and Ireland in the Union. And frustratingly, I think too many of these past experiences have been forgotten. And I refer to this forgetting as acts of constitutional amnesia. And my book retrieves and revisits these acts to explore the lessons that they provide. So you could say that these two themes running through the book are constitutional inadequacy and constitutional amnesia. And they come together in the phenomenon of Brexit, I think, which raised questions about both of them. And so in my book, what I did was to take 10 chapters separated out into 5 case studies of past acts of union and disunion, each involving Britain's role in the context of a wider community or a smaller community. So a wider community being the North American colonies in the 18th century, the British Empire and Commonwealth, the EU, the ECHR, or a smaller community being Scotland and Ireland, Britain's long-standing, or rather England's long-standing relations with Ireland and Scotland. So I had these 5 case studies, but I also looked at 5 themes which I took to be of particular salience to Brexit debates. And these were the issue of sovereignty, which I think is particularly at the core of Brexit. The whole take back control mantra was used again and again. But the question of sovereignty, I think, is interesting because not only was it very much at issue in the context of Britain's relationship with the EU, what exactly was it? Had Britain lost sovereignty by being a member of the EU? But looking back in history, one could see that there were similar debates, taking the issue of Britain's loss of the North American colonies in the 18th century. Parliamentary sovereignty was asserted again and again by Britain. And one could say that that whole episode could be reconceived as an issue of sovereignty, of parliamentary sovereignty. Exactly what type of control did Britain have over those North American colonies? And I found it very interesting that issues that had arisen many, many decades, hundreds of years ago, were being revisited again in this recent episode of disunion from the EU. So although Brexit raised all sorts of economic issues, trade obviously at the heart of it, there were also important constitutional issues, acts of union and disunion, and I felt that Britain had never really satisfactorily settled those. So as well as looking at the issue of sovereignty, I also looked at issues of union and disunion. The UK is a union. Scotland and England came together in 1707 to form the Union. And what can we learn by comparing that union, what it transformed itself into later, with other unions? So in that chapter, I looked at other unions, unions mostly within the larger European space, but also elsewhere. And I looked at unions over history as well to see what one could learn about that, because I think what's interesting is the fact that there are different understandings of what the UK union means. There is no one uniform understanding. Some people in Scotland might understand it differently from people in England. Is the UK a union state? Is it unified? Is it some sort of composite state? There are all sorts of historical comparisons that one might look at. And most of these were not explored at the time of Brexit by the UK government, which kept insisting on a very unitary, unified interpretation of what the UK was about, an interpretation that wasn't shared by everybody at that time and hasn't been shared for a long time. And this led me on to an investigation of issues of federalism, devolution, and differentiation. Because I worked for a while for the Scottish Parliament at the time of Brexit, after the Brexit vote. And I found it interesting that in Scotland, which had voted against leaving the European Union, there was at first an attempt to try and maintain some sort of relationship with the European Union and looking to other relationships that might be formed with the European Union. So I looked at devolution versus federalism. Devolution itself had been favoured by the UK's membership of the European Union. But on Brexit, that relationship came under strain. And there was an attempt by the Scottish government to look and see if other relationships could be formed by Scotland while remaining part of the UK with the European Union. And with Ireland, the relationship became even more strained. So this was a very interesting area to look at, and I looked at that as a theme in chapter 8 of the book. I then went on to look at the whole issue of democracy and referendums, the referendum being a rather unusual constitutional instrument in the UK. And the very fact that a non-binding referendum, the Brexit referendum, might somehow be seen as something that had to be implemented in itself was of interest. But that also raised the question of popular sovereignty, of the people voting in a referendum, what relationship that might have to the question of representative sovereignty, representative democracy, which has been traditionally the way we've understood democracy in the United Kingdom. So I had a chapter on that as well. Finally, I considered the way in which human rights have been impacted by Brexit, most notably because the fact that the EU Charter of Fundamental Rights was one of the aspects of EU law that notably was not going to be carried over into this whole area of EU retained law. And so not something that the UK would maintain on leaving the European Union, which raised the question, are human rights under threat in the UK? What can be done about that? And what has been the UK's traditional attitude to human rights? Are they precarious? Are they overpowered by parliamentary sovereignty? So I had these 5 case studies, these 5 themes, which are examined in the book. They all come together under a framework of Brexit, but an awful lot of the book, probably the larger part of it, is really a matter of constitutional history, I think, which is why the theme of constitutional amnesia has been so important to me. I found it interesting that when I was coming of age as an academic, looking at various disputes about sovereignty, debates, an awful lot of them related to the European Union, how one understands sovereignty in the European Union, issues of constitutional pluralism. But 80, 100 years ago, certainly within the larger Britain, at least, within the framework of Britain and its former colonies, those same issues were being examined in a very, very different light in the context of the former British Empire and Commonwealth. And yet there were surprising insights, things that people had to say about those that would be relevant. But they're not very often remembered by lawyers, at least. And of course, the British Empire had a legacy of a rather unpleasant violence, overuse of power. But I think that there might be ways to reclaim that, some of those issues without entering too much into the very unpleasant overtones of violence and power that some people see in the context of the British Empire. So there are concepts like dominion, the fact that federalism was explored in many of Britain's former colonies. What form did it take? What is it to be a federal structure? What about federacies, which are different from a federal government? How might they be explored? All of these issues somehow have been forgotten or chosen to be forgotten by lawyers, at least. So my book was exploring all of those issues, prompted by this major issue of Brexit. And I think by and large, it's more a work of constitutional history, but a large part of it also looks at some very salient issues in the British Constitution today and explores very much what the UK Union means today, whether it has a future, is it seen differently in different parts of the UK? Is it seen differently in Scotland? Is it seen differently in Northern Ireland? What does it mean that it's seen differently? What role has law played in these difference of visions? Very often in the former British Empire, there was almost an eschewal of law. We are a family, we prefer to do things differently. We like to keep things informal, but law actually played quite an important role, and it certainly played an important role in the Brexit referendum, which was achieved through law, but through ordinary law, because Britain has an uncodified constitution. So Brexit was achieved by ordinary acts of parliament going through an ordinary legislative process. So there are all sorts of really important, interesting constitutional issues to be explored, which came together through Brexit. And because Britain hasn't got a codified constitution, there was no special process to be followed for Britain leaving the EU. And perhaps in a way, the whole issue was minimized because of that, seen as something that could be achieved. On the other hand, there were some extraordinary parliamentary debates, some very heated, excited times, very exciting time for constitutional law. So it raised all sorts of issues. And I think it was important not to forget what had gone on in Britain's past, to see if anything could be salvaged from that. If anything could be salvaged, for example, from debates in the late 19th century, early 20th century, over Irish Home Rule, the three legislations, the three bills that were drafted to craft Home Rule for Ireland in the late 19th, early 20th century, raising a lot of similar issues that have been raised in the context of Scottish claims for independence or something less than independence. So I think there was a lot of importance that could be looked at again, and that Brexit should make us think about. So that was what the book was about this very unsettled constitution that Britain has, that may change or may not. It's difficult to know right now. We stand at a bit of a crossroads, but we've been at a bit of a crossroads for years and years and years. But will there be some attempt at codification? Will Brexit have proved to be a constitutional moment? I don't know. But certainly there were lots and lots of interesting questions, and these were the ones that I looked at in this book. So I'll stop there and look forward to hearing what others have to say.
That's perfect. Thank you so much, Sionaidh. Kenneth, over to you.
Thanks very much indeed, Max, and thanks very much to Sionaidh for the book. It's, as we can tell from the introduction, a very rich book with lots of important insights into the nature of the British Constitution. And I think for me, this kind of idea of the formation and demise of political and economic unions these are events that actually they lend themselves to the kind of historical contextual methodology that Sionaidh applies to Brexit. And of course, the Long Context series really does want to foreground all sorts of different contextual approaches to legal scholarship, and especially historical methodologies. It's very, very important. That's an important part of the work that Max, Sally, and I do as editors in the series. Now, this book positions Brexit at many ways at the end of, but also within centuries of evolution, really, of the British Constitution, including the formation of the Union State, or however we describe it, of Great Britain and of the United Kingdom, and of course then also the UK's own membership of the European Union. And in many ways, what I want to do in my brief remarks today is really to focus on that connection, that confrontation, if you like, between two unions, between the UK and the European Union at the moment of Brexit. What does it that moment reveal about the nature of unions and disunion? And so with that in mind, I think for me, Brexit provokes, it's in many ways, I think in Sionaidh's book, Brexit often becomes the context, or as she said earlier, the framework for analysing a lot of the things that she wants to talk about. And here I want to try and foreground it a little bit more, and to do so by asking, I think, really sort of three kind of questions that arise for me from thinking about the themes that Sionaidh discusses, my own thinking about Brexit, really. And the first thing is what sort of union is it that the UK left through Brexit? In other words, what sort of union is the European Union? And secondly, what did Brexit reveal about the different qualities of the UK and the EU as unions? So what kinds of what it becomes striking about the two unions in that moment of disunion, if you like. And then I think the third question, certainly the one that is far more speculative, is so Brexit didn't destroy either union. But what does it that then tell us about continuity, resilience, but also any potential future fractures or points of fracture or tension, particularly of the UK Union? So I just want to try do something which I feel is kind of embarrassed slightly. It's a very narrow take on what is a very rich landscape of the book that Sionaidh presents. But I think in the time allowed, I really wanted to try and focus on this idea of Brexit as the confrontation between two different unions, and what does that tell us about them as unions and unions in general. So if we start with the European Union, it has, of course, its origins in a set of communities, of economic communities. And therefore, European Union was an attempt to amalgamate, assimilate, integrate these communities into something else. And for that union to be also a political union and not just an economic union. And of course, one of the very important themes of Sionaidd's book is that relationship between economic union and political union, and the stresses and strains round about that. What I think is significant there, though, is that union is a project. It's not an event. It's not the act of union, or union becomes a dynamic element, something that is always kind of in the making. And I don't know if that's something that Neil will talk about later on, because I think it reflects with some of the themes of his own work. The European Union is also a union of peoples and states, something which it seeks to try and maintain while also integrating those peoples and Europes. It's a regional union, which I think is sometimes something we take for granted, but actually does need to be foregrounded. It is a regional union. There are other types of regional union, the African Union, for example. It's an enlarged union, again, reflecting that sense of incompleteness of a movable project with movable boundaries, which I think is, again, gives it quite a significant quality of its own. It's a union of values and purposes, and these are explicitly laid down in legal texts. And therefore it is a union with almost an explicit raison d'etre, which I think, again, maybe a point of contrast with other unions, including the UK. It's a differentiated union. Now, Sionaidh mentioned that earlier in terms of discussions of devolution, but I think in the EU context, differentiation also refers to policy differentiation and different degrees of engagement and involvement of the member states in different kinds of policy areas, most particularly economic and monetary union. It's a global union in the sense of aspirations to be a global actor and a global player, which again, I think is an important part of the identity of the European Union, not simply an internally facing union, but one that has an external facing role. It is, of course, a constitutional union in the sense that there are not just legal text, but kind of federal principles regarding divisions of power. There are aspirations towards the rule of law and the protection of fundamental rights. It's a voluntary union, as emphasized by Brexit itself. It has mechanisms for states to withdraw as well as to join the union. And finally, it's the banal point, it's a union of law. European Union law exists as an object of study and a phenomenon in of itself, a form of law beyond the boundaries of the traditional nation and sovereign state. So what happens then when unions confront one another? And Brexit, I think, is that moment of confrontation. The moment of disunion allows us to see elements of difference and contrast between the two unions. We could spend hours on this. Thankfully, we will not do that, and so this will be relatively brief. From the European Union side, what did Brexit tend to emphasize? I think the Article 50 process for the EU side was, of course, as it was for the UK, entirely untested. It had never been used before. But as I've been writing recently, it was a way in which the EU still deployed familiar routines. It deployed the power of routine and the power of law to try and manage what was otherwise an entirely novel process for it. For the EU, though, Brexit could have been seen as an existential threat, but at the same time was a way of allowing a continuity to be asserted, the continuity of the EU project, its resilience, and the reaffirmation, I think, particularly of the unity of the other remaining states. So in that sense, it was union reinforcing for those who remained, the other 27 member states. For the Union, the European Union, actually there are other just challenges out there which are perhaps more existential to it as a union, and that includes the rise of the far right and includes Russian aggression in Ukraine. So there are other things which put the union at stake, perhaps surprisingly more than Brexit itself. Looking at the UK side of things, Brexit, as opposed to the sense of order, routine, deployment of traditional bureaucratic processes in the EU side, Brexit was unruly. It was disruptive. It was meant to be disruptive. It was a disruptive idea in and of itself, challenging orthodoxies, challenging traditional ways of doing things, of business as usual. It involved a high degree of political churn and the consumption of politicians and political careers. Efforts, I think, though, were made to kind of reinforce a sense of Britishness. And other things happened at the same time or following Brexit. Everything from COVID to a coronation, which were there, symbols of its own unity despite all of this disruption and unruliness that as had happened in immediately surrounding the Brexit referendum and withdrawal. Lots of assertions of autonomy, autonomy externally, world trade, global leader, etc., and also internally, for example, new frontiers of attacks on human rights, for example, in the ECHR, again tending to emphasize Britain's unity, autonomy, sovereignty, etc. The system was stressed, undoubtedly, as Sionaidh describes in her introduction, but it didn't break. And that's kind of where I want to try and just finally deal with some questions round about that. Undoubtedly, Brexit was unsettling. and it took place in a somewhat unsettled constitutional landscape. But as I say, it didn't break it. So where has Brexit left Britain as a union? The hallmark of British constitutional order is this continuity of power, the continuity of power and authority, both at the level of monarchy, and again, we've seen the recent example of that, of the transition from Elizabeth II to Charles III, and then, and more importantly for present purposes, the continuity of government. And of course, at a political level, the idea of the sovereignty of Parliament is really a mechanism for the assertion of the political authority of union governments within the union state. At a legal level, parliamentary sovereignty is, for me, fairly straightforward. It's just a conflict rule that tells us that statutes prevail in the event of conflicts with other legal sources. Not much more to say on that, although others no doubt will have more to say on that. And in that sense, Brexit as a when we think about continuity of government, continuity of authority, Brexit runs with that. It doesn't actually it doesn't do something to dismantle that core sense of assertions of continuity of authority and authority of union government. I think where things are more unsettled are in those bits that Sionaidh looks at in the book, round about devolution and indeed round about human rights. Devolution, I won't say very much about either of those because I'm really running out of time. We can see the way in which Brexit has created tensions within the United Kingdom, the relations with the constituent parts of it. But again, they haven't broken. And I think that's a very significant question for the Scottish independence movement in the UK. If Brexit wasn't the thing that was going to break the union, what would be? Which leads to the second question, which is, well, these new attacks on human rights, the fact that Robert Jenrick can just very casually talk about withdrawal from the ECHR as part of his Tory leadership campaign, and it's never challenged. Nobody ever says, but that's an outrageous idea. How did you ever think that? The casual way in which that is being spoken of does lead me to wonder whether either that as the next thing in the evolution of the union would be the thing that would internally break the union, or not? Is it just that these things now have become so casual that these things can be said, and it's not the thing that breaks the union? So I think when we think about the unsettlement of the union, both pre and post Brexit, I think a really very central question, and one that is very hard to answer, is what really would break the union in the end? That is the end of my comments. Thank you very much.
Kenneth, thank you very much. Aileen.
Thank you. And thank you for inviting me along this evening. And particularly thank you for encouraging me to read the whole of this book from cover to cover. As we were discussing earlier, it really is a very weighty tome, and I do have a bad habit of just dipping in and out of books. So I'll come back to that, the reasons why I was pleased to have read the whole thing in a minute, but I really am. I did already have a copy of the book before I was invited, and I have to say, when I started to read it, it wasn't what I was expecting from the title, because I was focusing on that word Brexit. As Sionaidh has already indicated, this is not really a book that is directly about Brexit. Brexit does appear at various points, but Brexit is really more of a jumping off point here for a much more ambitious historical and conceptual survey of a range of constitutional issues that are raised by Brexit. And one thing to say about this book is there really is a hugely impressive amount of research that has gone into it. So, I'm in awe of that, Sionaidh. So obviously I can't do justice to everything in the book in 15 minutes either. I'm going to organise my remarks around about what Sionaidh described in her introduction as the two main themes or leitmotifs of the book, which is constitutional amnesia and constitutional inadequacy. I'm also going to focus on issues around sovereignty and the UK's territorial constitution, and I'm going to focus more on the historical aspects of the book rather than on the conceptual chapters. So constitutional amnesia. I have to confess that as I was reading the first chapter of the book, which is on Scotland, I was bristling a wee bit at the idea of constitutional amnesia because, you know, to me, this chapter was telling quite a familiar story. But as I read on, I encountered material that was a lot less familiar to me. And, you know, so I wondered if maybe constitutional amnesia wasn't quite the right term, but maybe constitutional silos, because I think different parts of the book will be familiar to different groups of readers. Even the things, you know, the chapters on the constitutional legacy of empire, there is actually been quite a lot of work being done on that in that area recently, a bit of a revival of interest in the constitutional legacy of empire. And there has been some degree even of beginning to break down these silos. I think one of the things that Brexit has encouraged us to do as academics is to maybe start to look outside our silos a little bit. And the example I was thinking of was the UK Internal Market Act, where there has been some conscious attempts to draw lessons from other internal market systems, including the EU internal market. There's also been some attempt to draw lessons from the history of empire. But even with these caveats, this book stands out just for the sheer scale and breadth of coverage, and for bringing what, you know, might initially be thought to be quite disparate historical and geographical events or periods into conversation with each other. And I think it does that in a way that is really illuminating of points of similarity between those different episodes, but also, of course, points of difference. So I did really learn a lot from this book. And I want to say in particular, a real highlight of this book was chapter 3, which was the chapter on the loss of the US colonies. That's something that I knew next to nothing about beforehand, and I think, you know, would actually lots of people would benefit from that. The chapter on the constitutional status of empire was also, for me, really, really interesting. Sections on the pre-Union history of Ireland. Again, I didn't know quite so much about that. So there was lots in this that I found really, really useful. And I would encourage people who are listening to this event to read the bits of this book that they don't know about, rather than, you know, not rather than, but as well as the bits they do already know about. I think it's that learning from different areas that is really valuable. Nevertheless, I mean, the question that remains for me is, well, what's the purpose of recalling these disparate histories of union and disunion to mind? And I think they're used in 3 different ways in the book. So the first, and I think the most obvious way in which they're used, is in an explanatory way. They have explanatory power that's valuable in and of itself. They tell us how we got here in constitutional terms. They help us to understand contemporary attitudes, contemporary debates. It's undoubtedly worth emphasizing that our constitutional history has not been the kind of standard Anglo-centric tale of gradual and unbroken constitutional evolution centered around the contest for power between Parliament and Crown. It's been a much more complex and much more contested history. A second use of history is that it might be a source of lessons for contemporary constitutional debates. I think there's a number of themes here that will resonate in the contemporary constitution: lack of legal regulation, a heavy reliance on convention and practice, a lack of consistent constitutional design, a neglect of the peripheries, contested understandings of where constitutional authority lies. In particular, the chapters on the Irish secession and the loss of the American colonies might be thought to tell a powerful story about the dangers of excessive centralization, the limits of trying to maintain unions by force, the need for protection of territorial minorities against the power of the majority. And these are obviously themes with particularly strong contemporary resonance. But drawing lessons from history, of course, always requires caution. There are different stories that might be told. For instance, Michael Kenny, in his recent book on fractured union, really warns against the assumption, and I'm guilty of this assumption, definitely, that muscular unionism will be an impetus for breakup of the union. There are other historical stories that could be told that might suggest otherwise, and the example of Scotland itself perhaps tells a different story, because as Sionaidh explains in the book, the union in Scotland was initially rather unpopular, but it came to be accepted for a very long period of time. And that was notwithstanding that Scotland had its own episodes of brutality and suppression, particularly after the Jacobite rebellion. So, and that maybe reminds us that internal politics are as important to the future of unions as the relations between different territorial units. There are also clearly differences between these historical cases, which sometimes makes the drawing of comparative lessons and also the imposition of symmetrical solutions quite difficult. One thing that struck me recently as a point of comparison between Scotland and Ireland, for instance, Northern Ireland, for instance, is that in Scotland, we tend to be keen on the idea of autonomy. We tend to be comfortable with the idea of difference. But I think that's a more difficult thing and a more nuanced thing in Northern Ireland, because as this book quite clearly demonstrates, for much of history, different treatment in Ireland meant discrimination. It didn't mean the opportunity to do things yourself. It meant, discrimination. Third thing we might try to do with constitutional history is to use it to draw conclusions about how we should understand the contemporary constitution. And something that is argued throughout the book is that the idea of parliamentary sovereignty has been historically contested, and that this gives us a reason to reject the Disunion account of parliamentary omnipotence. But this is where I think the use of history becomes most problematic. It's one thing to draw attention to the existence of competing views of parliamentary sovereignty, the possibility of different interpretations of what it permits or requires, but there is a risk of putting too much weight on competing accounts. The legal authority, for instance, for the idea of popular sovereignty as the basis of Scots constitutional law is quite weak. It's historically contested. It's poorly elaborated what exactly that might mean and how we might use that in contemporary debates, for instance, around about the right to hold a second independence referendum. These are, there's a lot of work to be done in using those concepts and unpacking them. Different historical challenges are not the same, and they're not necessarily mutually consistent. So the specific arguments that are used in the American colonies around about the illegitimacy of taxation without representation, those are really different to the Scottish arguments based on the fundamental status of the Acts of Union. And I think it's also at least a plausible reading of these alternative accounts that they're not so much rival legal interpretations of the Constitution, but rather political objections to the idea of unlimited parliamentary sovereignty. They're telling us a story not so much of constitutional uncertainty or constitutional confusion, but rather of constitutional discontent. And so, I think what we need to avoid falling into the trap, the opposite trap of the kind of argument that's made around about Brexit, which is Brexit is some kind of vindication of the true Dyson version of parliamentary sovereignty. You need to avoid the alternative, which is to say, oh no, it was a violation of some other alternative understanding of the Constitution. Brexit is an event which has shaped the Constitution. It's not neither a vindication nor a violation. It may have shaped the Constitution in ways that some of us don't like, certainly in ways that I don't like. But there is a political argument to be made about why its effects have been problematic. So that takes me, I don't think I've got very much time, like either takes me to the issue of constitutional inadequacy. And the questions I had here were, well, for whom is the Constitution inadequate? And in what terms and over what kind of timescale are we judging its adequacy? There is clearly a centre-periphery problem here. The attachment to parliamentary sovereignty over a relatively long time period now does suggest that it's functional for the majority, or at least for those who hold power at the centre. And even if you can point to examples where the kind of excessive assertion of sovereignty has been contrary to the interests of the centre, the loss of the American colonies would be a good example there. Well, you might respond, it's not sovereignty that's the problem, it's the use of sovereignty that was the problem. It was a political failing rather than a constitutional failing there. But even at the peripheries, I think the flexibility and the ambiguity of the UK Constitution are not always necessarily negative. The Constitution can be facilitative of, can be responsive to demands for territorial recognition. The example of the growing autonomy of the Dominions is one. Another closer to home and closer to current time period is, of course, the 2014 independence referendum, which was a voluntary response to the outcome of the 2011 Holyrood election. And you know, as I think Sionaidh does recognise at one point in the book, I don't think there's many Scottish nationalists who would really want to have seen the Acts of Union as an obstacle to that referendum or as an obstacle to Scotland becoming independent. So given both of these things, the attachment to sovereignty at the centre, its equivocal benefits and costs for those in the periphery, I do wonder if the sensible thing is maybe not to focus quite so much on sovereignty and to think, rather to try and downplay it a bit, to think about the regulation of the territorial constitution, ways of regulating the territorial constitution in terms of a range of other constitutional values. And I think there is actually quite a lot of scope for a more satisfactory, for a more nuanced, for a more pluralist interpretation of a regulation of the territorial constitution that actually doesn't bring you up against sovereignty. And we can see that in a number of recent cases. The UNCRC reference, the Section 35 Order Judicial Review, the independence referendum reference, which are all seen very much through a lens of sovereignty. But actually, the real constitutional issues were not about sovereignty. And it would have been preferable if we'd focused on those, the constitutional issues that were really at stake. And I think, you know, what we've seen since Brexit actually has been an attitudinal change rather than a change in formal rules. Sovereignty has taken on a kind of inflated sense of its own importance, which has crowded out the room for a more nuanced and more pluralistic understanding of the values at stake in the territorial constitution. But that is, you know, that's, as I say, it's been about attitudinal change. And that reminds us, of course, that the way in which constitutions are operated can change, even if the formal rules stay the same. So entrenchment is not necessarily a guarantee that things will stay the same over time. So I'll wrap up there. I think there is a lot of work to be done over in terms of how we make the union work better post-Brexit. But what this book has amply demonstrated, and I really thank you for this, is that these are not new questions. There's lots of potential options and potential lessons from history about how we seek to address those things. So thank you.
Thank you very much, Aileen. Over to you, Alvin.
Thank you, Max, and well, thank you for the invitation, Max, and thank you, Sionaidh, for this deeply impressive, meticulously researched, ambitious, and eloquent volume. So let me present some takes on this, working from my perspective as an historian. Sionaidh's presenting an analysis which sees Brexit simultaneously as a catalyst and as a showcase, I think, for some of the constitutional problems, this word inadequacies of the modern union state. She sees the union as defined now by an evident lack of purpose. It has been vitiated by, in her terms, a deep-seated historical and constitutional amnesia. But she also sees cultures of constitutional fudge and muddling on. And somewhere at the heart of this miasma lurks Albert Venn Dicey and his emphasis on indivisible parliamentary sovereignty, the death of which concept, of course, has been repeatedly announced, but which yet, zombie-like, still haunts the corridors of Westminster. But Sionaidh's also eloquently presenting ideas as to where some constitutional futures may lie. Although in my reading of the book, it's less a program of reform than a forensic pathology of constitutional disease, together with a more tentative set of diagnoses and prognoses. The direction of the work seems to be in favour of a more rigorously codified constitution. The Cabinet Handbook, as applied by the extinct cohorts of good chaps, clearly won't do anymore. And there's also some largely sympathetic treatment of federative and federal revisions of the UK Constitution, both predicated upon the arguments that parliamentary sovereignty has already been breached and compromised. Sionaidh and I have coincided at least one earlier seminar where we agreed on a great deal. Her frustration, especially at some of the constitutional legacies, indeed illegalities of recent governments, is contagious, and her forensic skill is deeply admirable. But let me reflect briefly just on 3 or 4 of her arguments and combine this with some very mild devil's advocacy at the same time. Firstly, she persuasively highlights the problems within the current UK and complements a set of robust insights into these problems with an array of more generic observations on how union states generally come apart. She emphasizes the role of war, the issue of imbalance between different players inside the union state, the behavior of central or federal government. This is a book which is persuasively concerned with the lackluster performance of union states, preeminently the UK, as judged by a range of measures, which Sionaidh was reminding us of at the head of this set of presentations. As a starting point, I think I'd briefly complement all of this with the observation that union states like the UK often survive for a very long time. And in a sense, the point that I'm making here chimes with Ken's earlier dwelling on continuities. I think it's worthwhile thinking about how and why unions stay together, as well as how and why they fall apart. Understanding the centripetal forces in union helps to illuminate the operations of the centrifugal. And indeed, both of these, centripetal, centrifugal, are not discrete, but rather porous categories. Historians of Austria-Hungary, which is occasionally invoked across Sionaidh's analysis, historians of the UK are increasingly interested in the longevity of these polities. That is to say, if these unions muddled along over decades or centuries, then actually maybe this muddle has in fact some political utility and interest beyond that of unionist apologetics, like those offered by Oliver Letwin, whom Sionaidh quotes at length in a critical passage of the work at page 380. Second, and linked with this, Sionaidh emphasizes, as we've heard, cultures of amnesia, fudge, and imprecision, which prevail across the Union state, and particularly in the UK Union state. I think she's absolutely correct in this identification. I'd further suggest that such cultures are not recent byproducts of union, but rather are often central to the functioning of complex polities such as the United Kingdom. We have cultures of muddling on because ambiguity has often been essentially wired into the project of union and its modification. These fudges often created a necessary cognitive dissonance within union states, wherein different parties could have simultaneously different readings of the same agreement, whether, as Sionaidh herself points out, in 1867 with the Ausgleich between Austria and Hungary, or in 1921 with the modification of the United Kingdom under the terms of the Anglo-Irish Treaty and the follow-on 1922 Irish Free State Constitution. Sionaidh discusses some of the politically necessary linguistic slippage with the Austro-Hungarian Compromise or Ausgleich. And if I could turn to the Anglo-Irish Treaty just very briefly, I think some similar arguments apply. In 1921, the Irish essentially wanted a sovereign republic, while the British would only concede Dominion status. But in 1919, members of the newly created independent Irish Parliament had sworn allegiance to the Gaelic concept Saoirseat Éireann, which was and is translatable in several ways, including either as the Irish Republic or literally as the Irish Free State. So independent Ireland became the Irish Free State, Saoirseat Éireann, in 1921-1922, because the Irish wanted a republic and because the British were accustomed through the Orange Free State province in the Union of South Africa to the notion of a free state within a dominion and imperial context. Through linguistic slippage such as this, fundamentally divergent readings of one constitutional settlement were, at least for a time, politically reconcilable. So perhaps what I'm suggesting is that in certain circumstances, fudges aren't a problem. They may be a temporary asset and one which in fact has been hot-wired into the history of union. Now, I'm also sympathetic to Sionaidd's reading of our collective constitutional amnesia, but I developed the point, just as Aileen has done, by suggesting that as in Ireland, where there's been a perceived tension between academic history and popular patriotic readings, so in England, there has been blue water between the preoccupations of historians and those beyond the academy. The latter, including some of the political classes, appear still to be wedded to nationalistic or Whiggish readings of English constitutional history and its perceived narrative of progress. Michael Kenny's work has been already name-checked, I think, in our discussion. These notions may also be wedded, I think, to the idea of a peaceable kingdom, mythically free from political violence, a notion which, for example, sees the violent collapse of the United Kingdom of 1801-1922, including the Home Rule crisis of 1912-14, the Irish Revolution of 1919-21, as emphatically somebody else's problem. That is to say, part of Irish rather than English or British history. And incidentally, it has seemed to me that of all of the historical analogies invoked after the Brexit vote in 2016, that looking to 1912-1914 has the most pertinence. Third, and linked again with what I've been arguing, Sionaidh emphasizes the union's lack of purpose and indeed makes a call specifically for a clearer sense of purpose and a less stark bifurcation from the union state. And again, I think this diagnosis is persuasive. I'd also suggest that union enterprises like the unions of the United Kingdom have usually started off with clearly defined pragmatic purposes, but that part of the current challenge of union is that these purposes have sometimes been superseded. The acts of union which created Great Britain and the UK successively were essentially canny business contracts which effectively addressed costs and benefits and vested interests, but which ultimately weren't associated with any elaborate statement of overarching principle or idealism, nor were they designed to be. There were, of course, such elevating documents elsewhere within the diffuse British Constitution, but they weren't statements of the purpose or usefulness of the Union state and its essential structures. And in the absence of a codified constitution, and given the contractual nature of the acts of union themselves, the UK was from the start a deal rather than an ideal. It had a clear purpose, but not a vision. So in short, I think I'd suggest that the problem is not wholly that the UK has lacked purpose. Its problem is rather that it has sometimes outlived its original or acquired set of purposes. Fourthly, Sionaidh is interested in broaching federalism as one of a variety of perhaps possible constitutional future landings for the UK. But of course, she is also very, very fully aware of the difficulties here, and she persuasively emphasizes the England problem, the problem of imbalance, and once again, the issue of parliamentary sovereignty. And I'd also underline some other aspects of the political and historical failure of federalism within the UK. And again, Aileen has made this distinction between the political and the constitutional. Of course, federalism has been a recurrent topic of debate within British, Irish, and imperial politics. Federalism has been broached, whether in the Habsburg Empire, within the British Empire, Canada, or within the United Kingdom itself, as a miracle cure for ailing unions of different types. But much has often depended upon the condition of the wider nationalities question or questions in play. And equally critically, much has depended upon the balance of advantage. Unionists, for example, have tended to embrace federalism when the prospects of something worse from their perspective have begun to coalesce. Nationalist interest in federalism has in turn tended to be associated with relatively more stable union polities where the possibilities of anything other than incremental advance have appeared remote. The moment when the balance of advantage and disadvantage for each of the contending parties equalizes out, that moment is very, very rarely achieved. And moreover, the history of debate on federalism in Britain from the late 19th century onwards has been one characterized by lack of definition and lack of popular traction. Federalism in Britain was recognized even by enthusiastic advocates like the Scot F.S. Oliver as an elite project and accordingly often limited in its embrace. And this leads, fifthly, to a further observation, namely that if the current union is constitutionally and indeed morally problematic, then the alternatives could be just as bad or yet worse. Some of the historical exemplars and analogies which are frequently deployed in the debate on the UK's constitutional history are, in fact, often deeply ambiguous. Now, like many of us, Sionaidh invokes the dual monarchy as a possible comparator for the UK. And part of the reason, I think, for the improved scholarly press awarded to Austria-Hungary over the past 30 or 40 years is the increasingly sharp understanding that whatever its complexities, it was replaced by a set of profoundly difficult successor states, which themselves replicated on a smaller scale some of the problems of the preceding empire. Austria-Hungary may, in the judgment of its opponents, have been a prison of the nations, sometimes called that, but Czechoslovakia, Yugoslavia, and other successor states had their own significant minority challenges. Historians of the Habsburg monarchy now seek to achieve a history defined in its own terms. By extension, it's also possible to read this history as one not of inevitable political doom, but rather of vital constitutional thought and experimentation, which complemented the wider intellectual life of the empire and which might even have been on the cusp of success by the outbreak of the First World War in 1914. But there is a however. This is a speculative argument about Habsburg potential rather than realization. And it's an argument which is inflected through much hindsight concerning the politics of Europe in the 1930s. Moreover, the imaginative constitutional effort across Habsburg Europe wasn't uniform. This constitutional imagination wasn't uniformly deployed across the two halves of the empire. In Hungary, rather, the preoccupation was with the Magyarization of the peoples of that eastern half of the empire. Political resistance and pushback from other nationalities was dealt with through vigorous policing and the no less energetic manipulation of the electoral process. Malpractice, which was patiently excavated by another Scot, R.W. Seton Watson, writing for a British and Irish readership through a series of highly influential studies published before the First World War. So in short, the inequalities within our union were and are real, but all was and is not rosy elsewhere, even with supposedly reformed union polities. 19th century advocates of constitutional reform within the UK, like Gladstone, like the founder of the Sinn Féin movement, Arthur Griffith, often pointed to Austria-Hungary, but they largely ignored the fact that dualism there brought not just winners, but also a wide array of constitutional losers. And finally, throughout this impressive volume, there are, at least to my mind, subtle suggestions that Sionaidh wonders whether the union is in fact beyond recovery, whether the tipping point has already been reached in terms of its reformability. A.V. Dicey could be inconsistent and became politically ever more entrenched, of course, in his later life. But alongside his Anglo-centric and ultimately vehement unionism, in 1886 he foresaw conditions where for him the clarity of the constitution and the rule of law might be so compromised within a future United Kingdom that the fight over union would no longer be worth the effort. Now, one of the central features of this Sionaidd's deeply impressive volume is its wrestling with the legacies of Dicey. But maybe here, with this sense that there are looming circumstances in which union may not be reformable, there is in the end some discernible, if narrow, common ground connecting Sionaidh with A.V. Dicey.
Alvin, thank you very much. Neil, it's always difficult to go last, but if anyone can do it, it's you. Over to you.
Okay, and thank you everyone. Sorry for the celestial light sort of shining down on me. There's nothing I can do about it. It has to do with the kind of bulbs we have in my house. So many thanks, Max, for putting this together. Many thanks, Sionaidh, for a really interesting book, and many thanks for the four commentators who have come before me, who have said all the interesting things I was going to say. But So let me just try and pick up on a few things. Maybe one thing that struck me listening to Aileen, she said that Brexit is more of a kind of a jumping off point for the volume. I was thinking, yeah, I would put it slightly differently. It's more like a kind of vanishing point. So if you think of it within, you know, perspective theory, you look into the horizon, there's a point in the horizon where you just can't see anything anymore. Everything comes together, and that's Brexit. So this is very much a, you know, it's a history of what comes before Brexit. And then when we come to Brexit itself, then of course Sionaidh has a lot to say about Brexit, but it's all very, very unresolved. It's almost like it's seen as a kind of crunch point in our history, and a point which, you know, remains in many, many ways unresolved. So I like to think of it as a vanishing point, not necessarily in the sense that the UK vanishes, but our understanding of its future becomes more obscure. Like Aileen, I wanted to focus on the two ideas, the two as Sionaidh said, the two leitmotifs of the volume, the idea of constitutional amnesia and also constitutional inadequacy. And of course, uncharitably, one might say, well, you could say that about any constitution. Any constitution suffers from amnesia, and any constitution suffers from inadequacy, whatever we mean by inadequacy. But I do think right from the start, it's clear that there is something quite distinctive about the way that Sionaidh wants to talk about this. Usually, when we're thinking about constitutional amnesia, we're thinking, at least in part, of a kind of practice of presentism within constitutions where you can't really think to the past. Everything is about what's happening now, etc., etc. And in constitutions which are entrenched, in constitutions which are renewed, like the French Constitution, etc., etc., and many, many times, you know, the emphasis is always on the present and what's happening. And there's a certain type of amnesia associated with that. And of course, there are also constitutions, indeed all constitutions, also have amnesia in the sense that they have a very, very particular version of their own tradition, and which can go together with the presentism, obviously, with a very, very selective view of the tradition. And older constitutions, it's more obvious. It's more obvious within the American Constitution and the whole secular theology of the American Constitution. But it's nowhere more apparent than in the UK Constitution, you know, where what you have is this kind of double whammy of, on the one hand, you know, a constitutional heritage, which, as the wonderful chapter on the American laws of the American colonies makes clear, goes back so long in terms of the hardening of ideas of parliamentary sovereignty, etc., etc. Goes back many, many centuries, but also it goes back many centuries, both in terms of the hardening of certain traditions, but also in terms of the exposure to the exposure to different sorts of ideas. So the whole point and premise of this book, as I see it, is to say, look, you know, this is an ancient constitution, but the idea of the ancient constitution is something which, you know, is unchanging, etc., etc., is doubly wrong. Is wrong because it's always wrong, you know, there's always an ideological aspect to that, but also because, just because it's such an old constitution, you know, it's had so many different, you know, developments, so many different interactions with other entities, etc., etc. And this book, I think, is absolutely fascinating for that. Like Aileen, I really enjoyed chapter 3, but also chapters 2 and 4, because again, I'm with Aileen on this. If you don't know about these things so much, then go and read about them. Chapters 1 and 5, not so much. I think chapter 1, because being Scottish, I know some of this stuff. Chapter 5, because actually the European history is more recent. So it's actually more within our kind of living memory. There's more of a sense of this as something which hasn't been forgotten, etc., etc. So I think, even from my point of view, is a very, very useful book. And one thing I would say about the method and the style of the book is it's extremely well written. You know, it might be very long, but you can read it reasonably quickly and without feeling that you're losing anything. And there's a sense in which I think the way Sionaidh writes, and I've seen this in her other work, you know, she has a kind of clear but unobtrusive presence there, right? She has a view, she has an attitude, but she's unobtrusive. There's not a deep dense theoretical framework which is going to constrain what she says and which is going to exclude all sorts of things. She puts it all out there and says, okay, here's a lot of stuff and I have some views about this, but part of what I want to do is to inform you and allow you to make up your own mind about these things. So for someone writing this kind of book on the sort of hidden history of the Union, so to speak, you know, she has a kind of perfect method, a perfect style for doing that. So I thought that worked extremely well. So on the other point, on the on why the Constitution might be inadequate, again, I think there's something quite specific about the UK Constitution here, because usually people's sense of inadequacy when they're talking about Constitution has to do with the aspirational qualities of constitutions. Written constitutions always have an aspirational quality. They're always saying it's always about, you know, a sense of the future and what might happen. Even the EU, which doesn't have a written constitution in these senses, very, very much has a, you know, someone memorably said it's very, very much, you know, it's a promissory note for the future, you know, and constitutions are always promissory notes for the future if they're written constitutions. So one of the ways in which it's very easy to talk about inadequacy in any constitutional framework is because the aspiration is never realised. There's always a sense, there's always a gap between the reality and the aspiration. And that's not the inadequacy, I think, that Sionaidh's talking about in this book. I don't think that's the way in which she's talking about in inadequacy. It's not about the unfeasibly aspirational quality of the Union. And here, I loved Alvin's phrase, you know, it's the Union was a deal, not an ideal. And I'm kind of looking for a way of saying that in advance, and I thought that puts it really, really well. And of course, the point being that I think that unions, by their nature, traditionally have been deals rather than ideals, with the exception of the European Union, as Kenneth so eloquently explained. And one of the reasons why the European Union is exceptional is, go figure, it was actually brought together by a bunch of democratic states. So there was a sense, there was a voluntariness associated with that union, which is not true. Someone's going to contradict me, but it's not true of any other union in history. You know, there would be dimensions of popular representation, but there would also be a structure of power, control, asymmetry, etc., in relation to the making of unions, which suggests that at the point of the making of the union, it's very, very hard to think of it in these kinds of aspirational terms. It's very, very much, our history of unions is very, very much a sense of a deal, and it's about the consolidation of that deal. And that doesn't make it a bad thing. As Alvin says, it doesn't make it a bad thing. It doesn't make fudge a bad thing. It doesn't make the keeping things together a bad thing. But it makes it very hard to think about the Constitution in these kinds of aspirational terms. Now, can I say something? I would like to say something about sovereignty and the way in which we've been talking about it, because I thought there was some really nice lines on sovereignty in the book, and so no one else is quoted from the book, so let me quote, okay, just to prove that I've read, or at least I've read one page. Okay, so on page 332, Sionaidh says, if the UK is to function effectively as a single state, then its constitutional structure should acknowledge this variety, and that's a variety of the four countries. Yet at present they do not. The UK has a constitution that is supposedly flexible, full of synergies, conventions to suit every situation. Except that they fail to do so, because most of this flexible constitution is political, not legally enforceable, and when it suits, Britain retreats into a hard minimal legal shell, an eccentric legal understanding of parliamentary sovereignty as impermeable, indivisible, and unshareable. I like this idea of the hard minimal legal shell. So my point here would be that, and I agree that we shouldn't make too much of parliamentary sovereignty, but I think there is a kind of danger often of misrecognition within the UK Constitution. All this talk about it being a political constitution, flexibility, etc., because there is a hard minimal legal shell. And that hard minimal legal shell is about sovereignty, but it's about sovereignty in different sorts of dimensions. It's about external sovereignty, ergo leaving the European Union. It's about parliamentary sovereignty, ergo the way in which we think about the devolution setup has always been, in a sense, conditional upon the sovereignty of Parliament. It's about executive sovereignty as well. You know, ergo we understand the ways in which, you know, prerogative power was pushed and indeed rejected in the two Miller cases. But there's a sense in which sovereignty in these three different contexts is often used as something. It's a conversation stopper. And as Aileen says, I mean, conversation stoppers aren't necessarily a bad thing, but they're still conversation stoppers. And there is a conversation stopping element, you know, to parliamentary sovereignty and to executive sovereignty and to the idea of external sovereignty. These are all important. The idea that it's just about parliamentary sovereignty, that's wrong. All of these different dimensions are important. They reinforce each other. They're often confused with each other. They're often used as ways to back each other up, even though they're separate and different, but they are important. And the idea that they are a hard legal shell does give them a conversation stopping authority that the political dimensions of the Constitution don't have. And I do think that's important. Now, one of the things that let me just say, just take a few minutes just to say, I said at the beginning, the idea of the Constitution as being a kind of vanishing point, and Brexit being a vanishing point of the Constitution. I think, if I'm allowed to go back to an aspect of Sionaidh's title, and she took from me this idea of the constitutional unsettlement. Now, can I just say that when I mentioned the constitutional unsettlement all these years ago, before both the Scottish referendum and Brexit, I didn't mean an unsettled constitution. I meant something else. I meant something which was, in a sense, the inverse of a constitutional settlement. In words, it was as hard as a constitutional settlement in terms of an actual established written constitution, except it was an unsettlement. It was something which preserved an unsettled situation and would do so in the long term, right? It was something which would preserve a kind of an uneasy equilibrium. And my argument was, well, what you have here is you have European membership, which takes care of certain sorts of structures and ensures certain types of devolution within the UK. You've got the ECHR, which is not an appendage to the EU, but it's part of that same European project. You have the Human Rights Act, you have a bunch of different devolved settlements, etc., etc. And it actually created a situation of almost stalemate between different sorts of ideas of the Constitution. And a stalemate which might mean that someday people would want to overcome it, but it's also a stalemate which gives everyone something, right? It gives everyone something. And of course, what happens with Brexit is that stalemate is broken, right? So suddenly the ways in which the external structures of the Constitution helped, in a sense, modify the idea of the unitary state within the UK, suddenly that's all gone. And you have to think of a way of remaking the Constitution without these external stalemate ensuring structures in place. And that's one of the issues, and that's one of the difficulties. And that's, I think, for me, a fundamental sense of what's difficult about Brexit in the post-Brexit moment. And of course, what we have there, and here I think, again, I like Sionaidh's approach, because Sionaidh manages to take a position, but also to be sceptical about her own position, right? You know, she takes a position which is more rationalist than, as Alvin says, and some other people within this sort of debate. She believes in the written constitution. She believes in the possibility of it. She believes that it could be a good thing. But she sees all the counter-arguments, both the practical counter-arguments, but also some of the theoretical counter-arguments as well, about whether this actually normatively is a good idea. But the point is, whatever the case and whatever the situation is, the danger is we have moved from a situation of stalemate, of kind of uneasy equilibrium, to a position where it's not the whole story, as Aileen says. It's not the whole story at all. But there is a toxic oppositional culture within the constitutional framework now as well. There just is. You know, it's something that's very, very difficult to avoid. You know, on the one hand, you have a sentimentalist, sometimes bordering on atavistic sense of, you know, the old UK and what it might mean, right? And the old empire, etc., etc. On the other hand, you have both movements towards independence, but also movements which say, even if we can't have independence, can we have some dimensions of the union state more further developed, perhaps more symmetrical, more reasoned, more rational, more embedded within the constitutional framework, whether that takes the form of a written constitution or not. And the danger is we don't have a political or a constitutional culture which allows these two sides to speak to each other or to find common ground. So somebody mentioned earlier, in fact, two people mentioned earlier the Michael Kenny book, and Michael Kenny makes a good point about the dangers in the present constitutional moment. And one of the dangers he talks about is what he calls chain reaction constitutional reform, right? That what you have is, you know, the Scots want something, the Welsh want something, Northern Irish want something, etc., etc. And then there's a pushback from the other side from the centralising element. So there's that sense of a chain reaction where the piecemeal nature of constitutional reform actually feeds on itself, right? It's not just that you can't get a fundamental solution, is that each piecemeal actually creates a chain reaction and creates other sorts of possibilities and other sorts of pressures. And of course, the other thing which he mentions, and which many people have mentioned, although it hasn't come through very much today, is that there's a structural bias in the UK Constitution towards self-rule rather than shared rule, right? And I think that comes through again in Sionaidh's book very well. It's not by coincidence that towards the end she talks about federacy and dominion status as being the things which are perhaps more constitutionally feasible within the UK context, where what you're talking about is a situation where the emphasis is very, very much on the degree of autonomy, the degree of self-rule, rather than shared rule. The kind of shared rule we associate with federal structures or with more symmetrical devolved structures, or indeed with any structure where you don't have this tribal opposition between those who want to go back to an old unitary system and those who believe in greater and lesser degrees of independence. So I think these are the sorts of dangers and these are the sorts of difficulties that I think that we confront at the moment. But congratulations to Sionaidh for, I think, writing a book which both reminds us of this, but also puts it in a much larger perspective, which both gives us, you know, a body of thought of possible ways of changing this and improving this, but also telling us how damn difficult it's going to be. Thank you.
Thank you very much, Neil. And let me just reiterate my thanks to all the commentators. Sionaidh, you have a very rich set of comments there to draw on. Would you like to respond? Would you like to say a few words in reply?
Yes, I certainly would. And I certainly value the amount of time and effort people have put into reading such valuable, very rich comments. I'm just going to say a few words to each of the commentators in turn, but I think I'd start by saying that I wrote this book between 2018 to 2021 when I had my Leverhulme grant, and it really was at the heart of all the Brexit furore debates and everything else. And I had been working for the Scottish Parliament. And I had seen what happens when one nation of the UK Union feels a very distinct difference from another part. I'd seen the opposition and the failure to work of certain things that are deemed constitutional conventions, the Sewell Convention, for example, saying that the UK government should basically allow the Scottish Parliament to legislate on matters within its purview. And I'd seen these conventions not really being respected. So that was at a particularly heightened moment in time, I think, when I wrote this. Nonetheless, I would say that my main purpose in writing it, which certainly I think was appreciated by our great commentators, was to do a lot of historical research, not to attempt to prefer any answers. I think that parliamentarians, people who are working as analysts, there are many others better placed to do that than me. So it was just to do a bit of archival research, look back, trawl through, and to make the point. I mean, there are a lot of people who had written about sovereignty, past issues, Arthur Berriedale Keith, Frederick Madden, names I hardly knew that had written so much about issues of sovereignty, divided government, less than 100 years ago within the context of the British Empire and Commonwealth, forgotten today. And some of those ideas, not all of them, of course, worth retrieving. Anyway, just to move on and briefly make a couple of comments on each of our commentators, starting with Kenneth.
You would imagine that will also feed into the scale.
Okay. Can you hear me?
Yes, we can.
You can, great, okay. Well, starting with Kenneth, I thought it was very interesting, the comments that Kenneth made about the EU and comparisons between the EU Union and the UK Union, and the fact that the EU Union is exceptional in being achieved by democratic states, something that we don't see in many other unions. But I think there is a curious comparison to be made between the EU and the UK. Both in some ways see themselves using this term sui generis. They're exceptional. They're trying to do something different. Maybe all unions present themselves in that way. But certainly Britain has a history of seeing itself as being exceptional. And I think that the EU has also done that. Conversely, the EU, as Kenneth reminded us, is a regional union. And I think that the UK Union, and before that, the British Empire, as Brian Simpson notably remarked, there was something that everybody realized that was a bit odd about this tiny little country appearing to try and govern far-flung quarters of the globe from London or whatever. So there was this big difference, certainly in past times, in past history, that the British Union, the British Empire, and what the difference between empire and union is, I think, is a vexed and interesting question, because I still think that the constitutional law of the British Empire is by no means clear. But the EU is at least territorially confined, and Britain in the past has not necessarily been clearly territorially confined. One other connection I've made in the book, which I think came up a bit in Kenneth's discussion, was the fact of the role that law plays. The fact that Britain in the past has claimed that, well, our union, it's friendly, it's family, the empire is friendly and family. The EU has a lot of the time focused on law as a means to do this. It's set down values, objectives in treaties, whereas this has been left a lot more open in the context of the UK. And this was something that Alvin picked up on, and others too, about whether leaving things open, fudging them a bit, might not be a good thing for unions. So I think that comparisons between the EU and the UK, some of them can be made. I think the sovereignty question was one of the biggest questions that arose in that context. And for a lot of people, it was obviously unsatisfactory. I think I'd go a bit further than Kenneth. I think that the sovereignty question was pretty fundamental. And to me, it wasn't just, maybe one could frame it in terms of priority, but I do think that the British Parliament voluntarily gave away some sovereignty in joining the EU, some parliamentary sovereignty, not necessarily its national external sovereignty, because it always had the option of leaving. But I think there was a restriction. And I do believe that once it had done that in the European Communities Act 1972, that was a pretty important moment. It established that could be done. Done once, I believe it can be done again. It could be done in the context of many different types of legislations. In the context of the Human Rights Act, the British Parliament could, if it chose, give away some sovereignty. It could formulate some sort of entrenchment that some believe it did in the context of the EU. So I think that was a pretty fundamental moment that some have sort of even deemed to be the death of parliamentary sovereignty. Moving on to Aileen's comments, some fascinating comments there. I found it interesting that Aileen talked about bristling slightly in the chapter on Scotland. I think that, having grown up in Scotland myself, I noticed the difference coming and living and working in England for many years. This history, this legal history, something that may be very familiar in Scotland, it's not familiar in England. As Aileen probably will know, I mean, you're working in England. And sometimes one felt that the English needed to be reminded, not least in the context of Brexit, when so many important constitutional principles seem to be ignored. And so I felt astonishment, really, at my ignorance in reading about the constitutional law, such as it was as the British Empire, and to a large extent reading about Ireland. But I think that for a lot of other people, the ignorance about Scotland is a reality, unfortunately, within the UK Union. And so that is just something unfortunate. There has been no adequate probe, as many commentators made the point that there's no real questioning of what the UK Union might be, because there is a lack of knowledge of the various nations, the various other parts of the UK Union. Aileen made a point that I think probably several commentators shared, that different notions of sovereignty, particularly this idea that popular sovereignty is a fairly weak notion in Scotland, and that there may be different objections to the notion of sovereignty. I agree, but I think all of the objections to sovereignty come together to make something quite important, which is quite a fundamental assault on the notion of sovereignty, parliamentary sovereignty within that, as developed by A.V. Dicey. And I just don't understand why an awful lot of the UK establishment continue to cling to that notion. I think it's past its time. Moving on to Alvin, I found your comments on unions absolutely fascinating. You made a comment about linguistic slippage, and of course that's a concept that's very, very useful and works both to the favor and to the detriment of those who are within the union. And you gave examples from Ireland, from Austria-Hungary. I think also within the EU, we can see that linguistic slippage working, where with a translation from, I don't know what the total of different languages of the member states of the EU is, but certainly sometimes that works in favor, sometimes it doesn't. And we've seen how translations, it simply isn't possible to translate from some languages to others, from Portuguese to Irish, or I don't know, Finnish is probably a translation that's going to be very difficult to make. But I think in the context of the UK, it's not such an old union. I mean, we're really only going back to 1707. So it's not such a venerated old union, and it may muddle on, and there may be a great advantage in fudging things. But I think we also can learn the lessons of unions that have not survived. We can look to Austria-Hungary, we can see, I mean, all I was really suggesting was that we can look and maybe pick up a few points of things that the Austria-Hungary Union did that were quite successful, that were picked up, for example, in the running up to the Scottish referendum in 2014, autonomy accents. I wasn't suggesting that we follow Austria-Hungary. In many ways, that was a disaster. So yes, there are advantages to fudges, but great disadvantages too. And certainly in the period from 2018 to 21, it seemed like there was a great need in parts of the UK that weren't in England, that weren't in London, to do greater definition work on what the UK Union might mean. Maybe that need is lessened now, maybe it isn't. Maybe we've moved on to other crises beyond Brexit that question the union less and raise existential points on climate disaster, COVID, pandemics, whatever. But those questions are still very much unanswered as to what exactly the union might mean. And I think there's still work that could be done on that. There's still interrogation to be had. Finally, on to Neil's points, I very much like your concept of Brexit as a vanishing point. Yes, that's it. That's really how I saw it, because so much of the book really was about the past, not the present, but with Brexit in mind. So very much indeed. I think just some points that you made at the very end about sovereignty, I'd like to pick up on. You mentioned a passage where I talk about where sovereignty is questioned has been questioned in the UK. Britain had a tendency to retreat into a hard minimalist legal shell. And I still stand by those comments. I think that they are really problematic. They've been problematic in the past, and they continue to be problematic because there's this real disjunction in the British Constitution between its legal aspects and the rest of it. And so much of the British Constitution is convention, it's loose, it's not formulated in terms of hard law. But it's very, very important. Constitutional conventions, whether it be the Sewell Convention on the relation between the devolved nations and the UK, whether it be about the role of the monarch in legislation, the need for royal assent. That is a constitutional convention that the monarch always gives their consent. But what would happen if they chose not to? They have the legal ability to act as they please and refuse. So I think that the conventions are extremely important. The fudging is very important. The fact that during the British Empire, there were all sorts of statuses that encompassed sovereignty, whether it be this very, very contested malign concept of the protectorate, whatever the hell that meant. But if you were living in a protectorate, I guess it was quite important to know who was actually sovereign and control, but that was never successfully established. So I think that it shouldn't be a conversation stopper. The hard legal shell shouldn't be a conversation stopper, because I agree with Alvin on this point, there was a lot of fudging. It wasn't clear at all. And this meant that from the loss of the US colonies through to Brexit, Britain has been particularly unclear about what it means by sovereignty. There are all sorts of nuances, aspects of it that have not been fully explored, that might benefit the views of others than those in the centre in London. And yet the retort has always been, well, parliamentary sovereignty, whatever, legal sovereignty, we have this. And I think that's a problem. And I think it's a problem that at some stage should be resolved. And I think that the very least one can say is, why are we still sticking to Dicey? Why are we placing, I teach first year public law, first year constitutional law, and we still spend a lot of time on Dicey. Maybe we should spend more time pointing out exactly what is wrong with his opinion, even although we have Brexited and left the EU. So I'll leave it there.
Huge thanks, Sionaidh. And that's great. It leaves us a little bit of time to see if we have questions from our very, very patient audience who are stuck with us, even though I'm conscious we are getting close to dinner time for very many people. And I've just seen online in the chat that there have just been 2 questions that have been posted. Mike, would you like to articulate your question to Sionaidh?
Earlier on, the subject of whether the ECHR would continue or not was raised. It was mentioned as a casual throwaway from Mr. Jenrick. My purpose is that applies to the rights we have as individuals. And I was suggesting in my message that there's a similarity to the rights we also accrue via international law, and I use the Charter of the United Nations, the right to self-determination. But where I want to go with this is basically the Advocate General during the Supreme Court hearing, when the Scotland Act was discussed, made the comment that the Advocate General does not dispute that the United Kingdom recognises and respects the right of self-determination in international law. And what I wanted to draw from that was we have one component part of the UK, namely Northern Ireland, which in a hybrid aspect of law, but partly international law, is allowed the right of referenda. However, since 2014, there's a clear continuing denial on behalf of the UK government, of whichever political party is formed, to deny the right of self-determination to the people of Scotland. And I stress, to the people of Scotland, whether they wanted to vote yes to independence or no to independence. And what I'm basically asking in my question is, if you ignore and set aside domestic law and used international law, does the right of self-determination of peoples, as applies through the Charter of the UN, can it be maintained if you have two parts within the UK where there is a difference being applied? End of question. Thank you. And I repeat, thank you for a very, very interesting discussion.
Shall I answer that question now? Yeah.
If you'd like to, yes, please.
Well, thank you very much for your question. I think the use of international law is rather vexed and problematic because although politically various parties may see it as something that's very, very persuasive and encouraging, and these might be treaties, UN treaties that the UK has signed up to. I think the problem is that unless they've been implemented and incorporated into national domestic law by an act of parliament, then the UK government is always going to make the argument that this is persuasive only. And a lot of judges in the UK Supreme Court are going to agree with that position. Because the UK is a dual estate with international law, the strength of international law domestically is only as strong as whether it's been implemented by an act of parliament, and it may not even have been implemented very satisfactorily. So I think that was one of the problems with the argument that was made about the right to self-determination, which is obviously seen as a very, very pressing, persuasive right. But legally, there was a problem as to arguing its efficacy, because there was no domestic instrument in UK law that could be satisfactorily maintained, as far as I'm aware. And that's not a great situation. Some countries don't maintain this dualism. Some countries, most of international treaties are automatically part of national law, but not in the UK.
Thank you, Sionaidh. Manor, there's a question which you've asked. Would you like to ask it?
Yeah, I just want to understand this because I can't seem to get around it. It's something I did in public law back in 2020 when I was doing my LLB. Now I'm doing my LLM. So it was just a question that was always on my mind, and I just want to help understand it better in terms of devolved governments like in Spain and Catalonia. So could you perhaps explain that a little more?
Sionaidh, just to tell you that the question in the chat is what part does comparative constitutional law play in union dynamics? Just to add to what Manor has just said.
Well, I think there are always very, very useful comparisons to be made. And I spend quite a bit of time in my book comparing Scotland and Catalonia, looking at differences and similarities. But they are different jurisdictions, and so one can always learn something. But the trouble is that if you are going to court and making a claim, which has often been the case, was often the case during Brexit, was the case in various claims that Scotland made to be able to utilise the right to self-determination, among other things, to hold an independence referendum. you have to be able to rely on law that's enforceable in the UK. And so some international law might be enforceable in the UK, but the comparative points are very often persuasive only. So they don't have the great utility that being able to point to something in the UK domestic law might have, the UK Human Rights Act, something like that. That's the problem. And these problems even go as far as the UK Acts of Union with Scotland. There will be problems enforcing that too for various reasons. It's obviously not international law, but there are problems there. So if you want to succeed in a legal claim, you've got to have an enforceable provision of law.
Thank you, Sionaidh. There's a question in the chat around whether parliamentary sovereignty is not really is really a concept that is an invention for the convenience of politicians. I would just add here, perhaps, if I may, a sort of a version of that, or in the vicinity of that question, in the following way. So Neil picked up, and I would echo very much that. My experience as a reader of your book was very much of your voice as an unobtrusive guide to constitutional history, a friendly, generous one, but certainly not at the cost of passion. There's plenty of passion in the book, in particular around the frustration to do with as a number of people have picked up, like Alvin, as to the a Dyson zombie coming back to life after its death had been announced many times, and you do argue, in particular, for example, on that page that Neil quoted from 332, that that we could and perhaps should be replacing the language of parliamentary sovereignty with parliamentary supremacy. You would prefer us to be using that. But you do say throughout the book, and you do on the following page, that you don't think that means necessarily that we should give up on the language of sovereignty altogether. That you do think that there is something, I think at one point in your book, you refer to sovereignty, in particular national sovereignty. This is in fact on the following page, 333, as a resource, as something that might be used. Do you think there is a kind of normative case to be made for sovereignty? Not the Dyson parliamentary sovereignty, but nevertheless, something there that you think is important to hang on to. I wondered whether you wanted to take a moment just to tell us why.
Well, I think a lot of states would make the case for sovereignty without having the same rather curious idea of parliamentary sovereignty that the UK does. And I think therein lies the difference. We have an extraordinary idea of parliamentary sovereignty in the UK that really excludes any possibility of entrenchment of anything, no matter how important it be. And I think that's rather sad. You could have a constitutional system that placed importance on sovereignty, and could do all sorts of interesting things with it. It might decide to share it in some cases and not in others. It might see a value in pooling it in some cases. But sovereignty in the UK just too often means parliamentary sovereignty. It just means that whatever Parliament can get through, can get voted and agreed on, will be the law. And we saw a lot of that during the Brexit legislation, particularly things like the UK internal market, the Northern Ireland Protocol, where important provisions of international law were simply ignored and parliamentary sovereignty preferred instead at the expense of international law. So I suppose what I would be mooting for is a different understanding of sovereignty. There may be problems with that understanding too. I can quite see that there might be, but we have this really extreme, rather unusual understanding. And I think that that is what we should be concerned about and should be concerned about getting rid of.
It could be some ways in which sovereignty then understood differently as a conversation starter, I suppose, not a conversation stopper.
Yeah.
Certainly, it started a wonderful conversation between us. And I'm sorry that we've run out of time. For those of you others who have had questions, we can think all sorts of things about Brexit, but there's at least one great thing that it's led to in this amazing book, and a reminder of the complex constitutional histories that we should be remembering. And so thank you, Sionaidh, very much for writing it, and thank you all to our commentators for your wonderful comments, and to everyone for joining us. And just to say again to you, Sionaidh, congratulations.
Well, thank you, Max, for arranging all of this as well, and to all the commentators. Thank you again.
Thank you, everyone.